All right. Hello, and thank you everyone for joining us today. My name is Olivia, and I'm the program coordinator here at API. And I'm so excited to be having this conversation with you all about the status of the ERA since 1972, as well as constitutional equality around the world. To start today, I just want to read off our land acknowledgement. The land on which Paulsdale is located is part of the traditional territory of the Lenni Lenape, called Lenape-Hoking. The Lenape people lived in harmony with one another upon this territory for thousands of years. During the colonial era and early federal period, many were removed west and north, but some also remain among the continuing historical tribal communities of the region. The Nanticoke Lenni Lenape tribal nation, the Ramapo Lenape Nation, and the Powhatan Lenape Nation, the Nanticoke of Millsboro, Delaware, and the Lenape of Cheswold, Delaware. We acknowledge the Lenni Lenape as the original people of this land and their continuing relationship with their territory. In our acknowledgement of the continued presence of Lenape people in their homeland, we affirm the aspiration of the great Lenape chief Tom Amend that there be harmony between the indigenous people of this land and the descendants of the immigrants to this land, as long as the rivers and creeks flow and the sun, moon, and stars shine. It is my pleasure today to introduce our panelists, Ting Ting Cheng and Jorie Dugan. Ting Ting is a civil rights attorney, activist, and director of Columbia Law School's ERA project. Before joining the ERA project, she litigated gender discrimination cases at Legal Momentum, the Women's Legal Defense and Education Fund. Earlier, she was an attorney at the New York City Commission for Human Rights and a public defender and an immigrant defense attorney at Brooklyn Defender Services. Ting Ting was the legal director of the 2017 Women's March on Washington and served on the National Organizing Committee. Jorie Dugan is a global legal advisor at Equality Now with over a decade of human rights and social justice experience. Jorie is a licensed lawyer in New York and a former public defender in the criminal justice system, child welfare system, and anti-human trafficking court. Additionally, she has worked for human rights NGOs in Asia, Africa, and North America to address gender equality and combat gender-based violence. Thank you both for joining us today.
Thank you.
To get started, I just wanted to ask you both, we'll start with you, Ting Ting. Could you just describe what the ERA project is and what your work there is?
Thanks. Thank you to the Alice Paul Institute for organizing this really important conversation, and it's truly an honor to be here. And before I start, I want to say that there's background noise, but let's ignore them. They are children. They might sound like banshees. Everything's under control. So the ERA project was founded over a year and a half ago, and I joined as the director a little over a year ago. And our mission is to develop expert legal guidance on the final ratification of the ERA to the US Constitution. So to that end, we've written a lot. We've provided deep legal analysis on the most pressing issues to do with both ratification and also the role of the ERA in establishing broader gender norms to our society. So we've written policy briefs and white papers and explainers and amicus briefs, and mainly to educate judges and students and our collaborators, advocates, members of Congress, and White House staff and the media on the ERA. I'll note that we've also organized an in-depth 2-day symposium on the ERA in March of this year. And we went over the rich history, the kind of very complex constitutional questions around the ERA ratification process, the relationship of the ERA to the 14th Amendment, and also the practical impact of the ERA on the ground and how it impacts people's lives. So I encourage everyone to visit our website and go to our YouTube channel, and also to subscribe to our newsletter to get our updates as well. And I'll stop there.
Thank you. So Jorie, kind of the same question. Could you tell us a little bit about Equality Now and the work you do there?
Sure, of course. Thank you also to the Alice Paul Institute and to Olivia and Ting Ting. It's good to be here with you all. Equality Now is an international human rights organization that uses the power of the law to create enduring equality for women and girls everywhere. We specifically work in 4 programmatic areas: ending sexual violence, ending harmful practices such as child marriage and FGM, ending sexual exploitation such as sex trafficking and online sexual exploitation and abuse, and achieving legal equality. And of course, under our Achieving Legal Equality program area, we dedicate efforts and resources to fighting alongside partners on the ground, such as the ERA Coalition, to have the ERA officially enshrined in the Constitution. And recently in January 22, we joined Davis Polk and other human rights organizations to file an amicus brief in the Commonwealth of Virginia et al. Versus Ferriero in support of the plaintiff and appellate's appeal into the United States Courts of Appeals for the District Court of Columbia Circuit, following the March 2020 erroneous decision in the lower court not to compel the federal archivist to certify and publish the ERA as the 28th Amendment to the Constitution.
Awesome, thank you, Jorie. So I want to kind of start with a broad question for both of you. Can we define constitutional equality? And then more specifically, just what generally is the ERA? And why is constitutional equality at the national level and around the world so important? Kind of a big question, I know.
I guess, I mean, I'm happy to offer kind of like a quick primer on the ERA to just start that off. And then we can go to the next, minor question of what is constitutional equality. Okay, so the Equal Rights Amendment, it's an amendment to the Constitution that's nearly 100 years in the making. Although, my view, I think women have been trying to add gender equality into the Constitution since the founding of this country. Obviously when Abigail Adams, told her husband to not forget the ladies. It's a fundamental principle that this democracy is grounded on. And so it's kind of a bizarre and sort of a shame that we are the only constitution of an industrialized nation without explicit sex equality protections in the Constitution. So after the 19th Amendment, Alice Paul and all of her other feminist leaders thought that, that was the first step in guaranteeing equality, regardless of gender, but it was not enough to fulfill on the promise of equality. And so they drafted the Equal Rights Amendment and first proposed it to Congress in 1923. So, next year is going to be the centennial anniversary of that kind of act. It wasn't approved by Congress until 1971 when the House passed it, and in 1972 when the Senate passed it. So to amend the Constitution, you have to get both chambers of Congress to pass it with a supermajority, so 2/3 of both houses, and then it gets sent to the states for state ratification by state legislatures. And the requirement is 3/4, so that's 38 states out of the 50 we have right now, although, that can change once we add other states to the union. But so after Congress passed the ERA and sent it to the states, it was very quickly ratified by almost all the states. The one hitch was that as a concession to getting members of Congress to support the ERA, I think the people who supported the ERA agreed to this proposal to attach a 7-year time limit to the amendment process itself. So under that theory, the states would then only have 7 years to ratify the ERA. So this is an act of Congress. That deadline passed in 1979 and then was extended for another 3 years to 1982. And by those deadline extensions, by the deadline passage, only 35 states had ratified the ERA. And I don't mean to say only, I mean, that's a huge feat, 35, but that is 3 states short of the requirement of 38 states. It wasn't until 2017, 2018, and 2020 when Nevada, Illinois, and Virginia, respectively, ratified the ERA, thereby satisfying the constitutional amendment to amend the Constitution. So right now, there's, as Jorie noted, there's active litigation in federal courts to ask the judge to compel the archivist of the United States. Their job is to basically acknowledge each state ratification to kind of rubber stamp it. And then once you get to the constitutional requirement of 38 states, to finally publish and certify the amendment to the Constitution. And so that person, it was a he stepped down, refused to do that because of a Trump era Department of Justice memo declaring the ERA dead and essentially ordering him not to do that. And so there's a lawsuit, there's active congressional action to vote to lift the original time limit and to remove that barrier to a legal acknowledgement of the final 3 ratifying states who did so after the deadline had passed. And then there's also, executive action within the Department of Justice to change that legal opinion on the status of the ERA. And also the Biden administration has, very, very vocally supported the ERA from the beginning. That's kind of the landscape that we're working with right now. And then there's also the apocalypse. Obviously the recent Dobbs leaked opinion is signaling that, is first of all showing us that the foundation of equality in this country is actually quite weak. That's why we need the ERA. I think women have experienced huge advancements in equality, but also are vulnerable and subject to major rollbacks. This sort of the end to a 50-year constitutional right to abortion is a major setback for women. And it just shows that without an enduring and pretty permanent protection in the Constitution, the rights of a majority of citizens or, people in this country are going to be subject to the whims of the political tides of Congress.
And just to add to what Ting Ting said, I completely agree with the importance of passing or publishing and certifying the ERA now, especially because having constitutional quality in something as foundational as the Constitution, it just creates this foundation that everyone has equal rights under the law, and it cannot be. There's a constitutional protection against non-discrimination based on sex, which is, in terms of international human rights standards, a really critical tool that all countries should have and states should have. And to your question of, can we define constitutional quality? We do think that the text of the ERA is a great definition of constitutional quality. Thank you, Alice Paul. It guarantees equal rights for everyone, and it guarantees non-discrimination based on sex. And as Ting Ting touched on, it's important for so many reasons, right? It would provide stronger permanent protections and legal remedies that just aren't afforded right now to complaints of bias and unequal treatment. It would raise it to the standard of strict scrutiny, which it would be extremely important and is needed. And it really would prevent protection of rollbacks of rights that we currently have, and it wouldn't be at the whim of whoever is in office or whoever is in Congress. But one really foundational, a really foundational important part about why we need constitutional quality at the national level is because it also sends this incredible message that in America, women's rights is a fundamental right. It's a human right, not just in theory, but in the law. And we see all around the world that constitutions are the highest law of the land, and thus they set a critical legal foundation for protections and really promoting substantive equality. And really setting a statement of what, as a society, we value and how we should treat people and others.
Awesome. Thank you both. You both touched on so much that I want to get into. So some of the things we talked about, I'm going to come back to. But I wanted to turn to you again, Jorie, and ask, can you give us a sense of how the USA measures up to the rest of the world when it comes to constitutional sex equality?
Sure, great question. The US compared to the rest of the world when it comes to constitutional sex equality really could be considered a global outlier. In fact, the US falls behind 165 other nations that have stronger and that have constitutional protections for women. In fact, among the 193 UN member states, 85% of them guarantee equality or non-discrimination based on sex and or gender directly in their constitutions. And worldwide, 94% of all constitutions that have been adopted since 1970 have already included a guarantee of equality on the basis of sex, including all of the constitutions that have been adopted since the year 2000. And it's not just new constitutions. Many nations have also amended an older constitution and added guarantees of constitutional equality on the basis of sex. We've seen that in France, in Germany, in Luxembourg. So really, the US is a global outlier. And ironically, as a country, our government has insisted that equal rights provisions be included in the constitutions of other nations, such as Iraq, yet this same provision is missing in our own constitution. So we really do fall behind the rest of the world when it comes to constitutional equality.
Thank you, Jorie. That's really kind of amazing to hear. It's really eye-opening in a way to think about this on an international level and get outside of the completely US context. So Ting Ting, I wanted to come back to the issue you brought up earlier of the 7-year deadline that was put on the ratification of the ERA. So can you explain how legal scholars interpret this and what was the legal argument for the deadline?
So the deadline is not something that's required by the Constitution in order to amend the Constitution. And so many scholars believe that, it's not enforceable when it comes to having an amendment that has satisfied all of the constitutional requirements, which is written in Article 5 of the Constitution. And so already you have very, very high standards to amend the Constitution, right? And almost like a bar that's so high that you can't really imagine, the current Congress really voting for something with 2 majorities. I mean, the Senate approved the ERA in 1972, I think 84-8. I mean, that's, incredible, unimaginable in today's age. It's also was one of those very much a GOP-led initiatives and always had so much overwhelming bipartisan support in both houses of Congress. And so to go back to the time limit, it's not a constitutional requirement. And so there's a strong argument for it being not absolutely enforceable when it comes to the question of whether the ERA has been validly ratified or not. And the other thing to look at is the sort of historical practice. Many amendments, including the first 17 amendments to the Constitution, did not have time limits attached. So that practice itself is not something that was always a part of the history of this country. It was imposed later on. And you can look to the 27th Amendment, which is the immediately preceding amendment that's been added to the Constitution. And that is called the Madison Amendments. It was proposed by the first Congress and took over 200 years for the states to ratify. And that had to do with the regulation of congressional pay raises. And so when you look at something like that being able to be added to the Constitution without really a big to-do, I don't think there's anyone around that I know of who's going to dedicate their whole lives to litigating, in opposition to the 27th Amendment. But I do know that there are people that might spend their whole lives opposing the ERA. So that's another thing to consider as well. The other thing to consider too is that it's an act of Congress. And so in a democracy, Congress being the most democratic and the most representational body of our government, the acts of one Congress should not be binding on future acts of Congress. That's what Congress does, right? They are sort of democratically are receptive to the electorate, and they make laws and they change laws all the time. And so for them to pass a 7-year time limit is fine. And then they also decided to pass a law to extend it, which is fine. And now there are resolutions that have been passed in the House recently in 2 separate sessions, and a similar resolution that's being sort of that's proposed in the Senate, and hopefully we'll get a vote in the Senate as well to lift the original time limit. But there's also a strong argument that what they do is showing their support, because the Constitution doesn't say that there needs to be a time limit imposed. So that's where we're at right now. The Supreme Court has not squarely answered this question. And so I think what we're doing is working out some legal complexities that actually have never really been dealt with in the past.
Thank you, Ting Ting. So I want to get into that question of Roe v. Wade, but I want to first turn to you again, Jorie, because I think this will be related to our next question. So I wanted to ask, how have you seen and have you seen constitutional equality help eliminate sex discriminatory laws in other countries?
Yeah, that's a great question. So we've seen country examples of constitutional equality being used to eliminate sex discriminatory laws. For example, age of marriage in Tanzania. The Court of Appeals in Tanzania upheld a decision finding that the Law of Marriage Act, which allowed girls of 15 years old to be married off with parental consent, or to be married off at 14 years old if granted permission by the court, while boys had to be 18 years old to be married. The Court of Appeals in Tanzania found that this law, or this Marriage Act, was unconstitutional and in violation of Tanzania's constitution, which guarantees equality on the basis of sex. And the law was found unconstitutional not just because simply the ages were different, but because of the effects and consequences that could be shown, right? When girls are married off at such a young age, it can have an effect on their reproductive health, on their education, and it could increase their risks of violence, including sexual and domestic violence. So in 2016, we saw that the law was challenged and it was found to be unconstitutional, and the marrying age was raised to 18 for girls. While the government still needs to amend the law, this outcome really was in great part due to Tanzania's constitution already guaranteeing equality on the basis of sex. We've also seen examples in Nepal, for example, with marital rape. So marital rape is expressly legal in many countries around the world, leaving women very little recourse when they're victims to marital rape. But in Nepal, a national NGO called the Forum for Women in Law and Development, FWLD, challenged the exception for marital rape on the basis of women's equal rights in the Constitution. And in 2002, a decision by the Nepal Supreme Court cited the Constitution's equality guarantee and pronounced that, there is no justification in differentiating between women who are wives and other women. And they specifically referenced, in addition to the Constitution equality guarantee, they referenced CEDAW's expansive definition of sex discrimination, which is pretty expansive. It says that any distinction, exclusion, or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. So we saw that Nepal Supreme Court combined CEDAW's definition of sex discrimination, called upon their own constitutional guarantee for sex equality, and they were able to call upon the legislation to find marital rape or define marital rape as a criminal offense. And in 2006, the parliament did just that. They criminalized marital rape. So we've seen examples, not just those two, we've seen examples from other countries around the world. 10 national Supreme Courts, for example, over the past just 40 years, relied on constitutional equality provisions to invalidate sex-based qualifications in national citizenship laws. We see that in Japan, in Germany, in Italy, in Botswana, in Zimbabwe, Nepal, and Scotland. We've seen Colombia, Germany, and Spain use constitutional guarantees of equality to eliminate laws that discriminated against pregnant women, and particularly in relation to parental leave policies, emphasizing that constitutional gender equality makes a difference for both men and women when it comes to economic and family opportunities. We've seen in Uganda, the Supreme Court invoke the constitutional guarantee of equal rights in marriage to strike down customary law that required women to pay back their bride price, similar to a dowry, upon divorce, because men face no similar requirement. So we've really seen how constitutional guarantees of equality on the basis of sex can be used in a full range of political and social settings and in every hemisphere of the world. So it really does make a difference.
Thank you, Jorie. So kind of related to that, I want to come back to you, Ting Ting. So you mentioned this earlier, but earlier this year, there was a draft of the Supreme Court memo that was leaked that revealed that the court will likely overturn Roe v. Wade. So can you talk about what the ERA will mean for reproductive rights in a post-Roe world?
Yes, so, well, first of all, it's just completely catastrophic and devastating. You know, there's 50 years of precedent. And so on a very kind of basic level, we're looking at a Supreme Court who we cannot look to our Supreme Court to vindicate our civil rights. So that's totally devastating. And also, you know, I'm reading the opinion and I see that Justice Alito is completely willing to wholesale ignore 50 years of precedent coming from his own court and his predecessors, and to cherry pick from kind of sources that allow him to completely write, you know, women out of the Constitution, some more, and then to rely on sources from, you know, an era or from sources that directly treated women like property. And so I think that things are going to get a lot worse from here before they start to get better. And even though he said in that, again, it's a draft opinion, we don't have the official opinion, we don't, you know, we can't really fully read the tea leaves, but there's a strong likelihood that that's a signal for what's to come. The other thing is that there's a strong signal from him in the way that he's written the opinion to sort of kind of state that, you know, this isn't a one and done. It's not just about abortion or access to reproductive rights, is that it's going to, I'm fearful, set off a dominoes effect, and to look at all of these other protections that were found to be protected under the privacy right, under the 14th Amendment's due process clause, and to start to kind of chip away at other rights. So, and I don't really know where that logically goes, but certainly, you know, like marriage equality, right? Same-sex marriage, same-sex sex, contraception, you know, maybe even, you know, a lot of things are under threat. And I can't really fully underscore just how catastrophic this opinion is. I think the equal right, the ERA is exactly what we need in this moment, because it would amend the text of the Constitution. And so, you know, we have kind of a majority of judges on the Supreme Court who are now willing to wholesale get rid of like well-established precedent based on this theory of textualism, you know, that if you do not read it in the words, and if it was not the original intent of the people who wrote the Constitution in 1787, then it is not in the Constitution today. And that is just very, I don't know, archaic. I don't know what the word is, kind of a very black and white reading, and also completely not responsive to the current kind of our daily lives. I mean, you know, electricity wasn't around when the founders wrote the Constitution. Many things that are very important to us today were not around during the founding fathers' time when they wrote the Constitution. And so are we going to cut everything out, or is it just a matter of cutting out certain things because it benefits white male patriarchy? I mean, you know, what is it really? Let's just call it what it is. What is this really about? I think the ERA would change the Constitution the text itself. And I would like to see Justice Alito and all the other textualists on the court do a dance around actual text of the Constitution. The other thing about Roe and the right to abortion is that it's grounded in the right to privacy. I think that that's more narrow than a right to equality when it comes to reproductive rights and a constitutional protection based on a woman's right to choose or people's sort of like fundamental bodily autonomy. You know, under the privacy right, I don't know, it's always been framed as kind of like a really important decision between a woman and her doctor, you know, that happens behind closed doors, right? It's a right that flows from the body. So the attention is always on the body. And as you can see in the last 50 years with anti-abortion kind of like mobilization, it's been about chipping away at that privacy right of the doctor providing abortions, you know? And so with the equality argument under the ERA, it's really about, you know, a person's equal access to, in this democracy, you know, equal access to educational career attainment, to, you know, robust participation in the economy, right? To, you know, to choice, to the fundamental choice of whether and when to have a child. And all of these other issues that come into play when you're looking at abortion and reproductive rights in an equality lens, which the ERA would do, and I think would be very important.
Thank you, Ting Ting. That was very important to talk about, and I'm glad we were able to talk about that. So Jorie, I want to come back to you. So what do international law and human rights standards recommend regarding constitutional equality?
International human rights law and standards regarding constitutional equality are definitely out there, and adopting the ERA is important because it would bring the United States more in line with international human rights standards around gender and sex equality. And for these standards, we can look to some of the foundational international law instruments, including the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, which the USA has not ratified, but it has signed, which subjects it to certain obligations. We can also look to the Beijing Declaration and Platform for Action, the Universal Declaration of Human Rights, the American Convention on Human Rights, and the International Covenant on Civil and Political Rights, which the US has ratified. All of these instruments call for people to have the full enjoyment of their rights and freedoms without any discrimination on the basis of sex. Specifically, CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, Article 2 of CEDAW directs states to condemn and eliminate discrimination against women in all of its forms. And to this end, states should embody the principles of equality of men and women in their national constitutions, or in other appropriate legislation, if not yet incorporated therein. Similarly, the Beijing Declaration and Platform for Action, which is a United Nations resolution adopted to advance the implementation of CEDAW, specifically calls on countries to provide constitutional guarantees and or enact appropriate legislation to prohibit discrimination on the basis of sex for all women and girls. And finally, the ICCPR, which the USA has ratified, provides certain rights, including equal rights between men and women, protection from discrimination based on sex, and protection from sexual violence and gender-based violence. And it also requires that state parties, which the United States is a state party, takes the necessary steps in accordance with the state's constitutional processes to adopt such laws or other measures to give effect to the rights recognized in the ICCPR. So the US has obligations under international law, and we can also look to the standards of international law to really show that nations' constitutions, including the United States constitutions, are considered and encouraged to be the main instruments when it comes to establishing equality and preventing discrimination on the basis of sex.
Thank you, Jorie. So I have kind of a follow-up question to that. So it is an international human right, as you're saying, gender equality. So I'm wondering, is there pressure from the international community on the US to pass something like the ERA? And how do we see that?
That's a great question. So under international law and the ICCPR, which the US has ratified, the US has an obligation to have the full enjoyment of rights for all people and not discriminate on the basis of sex under international law. That alone should be pressure on the United States to live up to the obligations. But it's a great question when it comes to the pressure that it's facing. I think the world is watching, right? The United States likes to hold itself out as a country of the freedoms and great rights, but there's a stark contrast to what we say and what we do, which is why if we finally enshrine the ERA into the Constitution, it finally sends a message that not only do we say we have equal rights between men and women, but we do so in a way that it's enshrined in the law, it's protected under the law, and we should care that we are an outlier in the global arena when it comes to this. And a great quote by one of our partners, Jorie Heyman, who wrote a book on advancing equality worldwide, and I'll pull up the title and recommend it later for our audience. But one of the major quotes that she said that I think is really important for this is, after knowing that we're a global outlier in all of this, what does it mean when we know that we're not living up to constitutional equality, or we're failing our women in the United States versus, the rest of the world? Why does it matter? It only matters if we care. And I think that's the pressure that we need to put on ourselves. We need to care. We need to make our senators care. We need to make our government care. And the rest of the world is watching. And I think it would send a message and bring us in line with the global community on gender equality and sex equality, if we live up to our obligations and actually protect the rights of women and protect against discrimination based on sex in our Constitution.
Thank you, Jorie. I love that quote. It's very powerful. So I want to pose a question.
The quote. It's not the exact quote, but
yeah. I want to pose a question for both of you. So what can people listening do if they want to get involved in the fight for the ERA or gender equality around the world? Ting Ting, do you want to start us off?
Is this like a global international law question? If it is, I think I'm going to let Jorie take it because she's the international comparative law expert. I'll break this into two questions.
So what, to anyone listening to this conversation, they want to get involved in fighting for the ERA, what would you say?
Oh, great. I'll take that. Before I answer that question, just to piggyback onto what Jorie was saying. So Jorie Heyman is also one of our partners, and she was a speaker in our symposium on the panel that we had on the ERA in practice. And she's just so amazing. Her research is so just comprehensive and like brilliant. And then the other, there are two researchers at the Harvard Kennedy School, Professor Erica Chenoweth and Zoe Marks, who's a lecturer there. They study sort of like the rise of autocracy and women's movements globally. And so they've done an interesting study to look at how there's a rise globally in sort of like autocratic governments, including here. And also what's been really effective in opposing that is actually kind of grassroots women's-led movements on the ground. And there's that kind of like tension there, but they have written extensively about that, have studied kind of like women's movements in that context. So I encourage everyone to check out their writing and their research. So what should people do? I mean, at a very kind of like high level, I just want to stress again, the Constitution was drafted in 1787. And at that time, women were not included in the Constitution. Black people, people of color were not included in the Constitution. Most people were not included in the Constitution. In fact, when the Constitution was drafted, the drafters made the slave trade unamendable for 20 years. And we have the hardest Constitution to change today, And so one of the things that I encourage everyone to think about top level, take it away from this talk, is that, is just to remind yourselves, like, who is the constitutional Constitution for? When we talk about discrimination or, gaps in the ways in which the Constitution or federal or state or local laws fail to protect women, pregnant women, working women in the context of all across, different sectors, it's those rights are and protections are even harder to access for women of color, especially Black women, immigrants, people with disabilities, sexual and gender minorities. So, it's been said that kind of a measure of a great society is how well the democracy treats the people who are the most marginalized and the most vulnerable. And so that's what the ERA is for. And we can't forget that. Like, it's not just, a bunch of constitutional lawyers or people who, quite frankly, are very well resourced and have a lot of access to rights talking about this in the abstract. It's about kind of the practical, on the ground impact of people's lives. And that's happening all around us. When Roe falls, when the Dobbs opinion is, officially released, that's going to be, incredibly catastrophic for many people in this country, particularly Black women. And so to keep that in mind and to focus your education and your advocacy with that in mind, sort of remind yourself, who is the ERA for? How can the ERA impact the most amount of people, and to let that drive, the advocacy that you do in your own communities.
Thank you, Ting Ting. And Jorie, if people want to get involved more globally, what would you have to say?
Sure. Well, so in terms of like global, you're welcome to go to Equality Now's website, which is equalitynow.org, and you can see all of the ways that we are working to achieve legal equality all around the world. But specifically, Equality Now's strategy to help with the US is to amplify the voices of the grassroots groups that, Ting Ting had mentioned. So I also encourage you to go to the eracoalition.org if you haven't already. And as I looked up what the name of that book is, Jody Heyman is wonderful. And the World Policy Analysis Center is also a partner of ours. And the book that I encourage you to read if you're interested, not only in the ERA, but the global legal equality information, is called Advancing Equality: How Constitutional Rights Can Make a Difference Worldwide. And I would just like to echo Ting Ting's great point about how conceiving advocacy moving forward and really highlighting the fact that constitutional equality can be used to prevent future discrimination on the basis of sex, and really make up for the gaps of protection and systemic and systematic discrimination of marginalized populations. Because, as Ting Ting mentioned, women, and often women of color, are the most devastated and impacted by sex discrimination and inequality. And we've seen in other countries how constitutional equality has been used and is trying to be used intersectionally to right these wrongs.
And I just want to plug our website. It's ERA Project at Columbia Law School. So the coalition is one of our partners as well, but we are a separate entity. So if you Google ERA Project at Columbia Law School, you'll find us.
Awesome, thank you. So we have about 10 minutes left, so I'm going to take a couple questions from the chat. And if you're listening and you have any questions, feel free to throw them in the Q&A. Okay, so the first question I have from the chat: if the ERA gets certified, the states that have rescinded are going to file a lawsuit. How are pro-ERA activists going to fight this suit?
So there are a handful of states who ratified the ERA in the 70s and then subsequently voted to rescind their ratifications. 4 of those 5 states did so in the 70s, and then 1 state had a sunsetting provision, which basically said if the ERA doesn't become ratified by the deadline, then their ratification would expire. There's just no historical precedent or no kind of legal practice to even acknowledge rescissions. And, there's a pretty important kind of like democratic principle behind that. It's, constitutional amendment is incredibly hard to achieve and is the foundational backbone of this country. And so states can't just, choose to ratify and then take that back. But I guess the short answer is that we don't know what kind of lawsuit would play out in the courts, but certainly there's no historic precedent or any kind of Supreme Court precedent in support of acknowledging a state rescission to a ratification to the Constitution.
Thank you. So the next question I have, so what can we do on a state basis for the ERA? And I think state basis, like New Jersey, Connecticut is probably what they mean there.
Sure. I mean, I can take that. And one of the things that obviously we are focusing on the final ratification of the ERA, and at a constitutional level, especially when we're talking about the lawsuits or congressional action, it has to do with providing legal analysis on the sort of the legal theories of ratification, and also analyzing these questions of the perceived legitimacy of the ERA ratification process. The other thing that we're really focused on, which is more of a long-term goal, to broaden the impact of the ERA to the Constitution by opening up the conversation about like, what does this protect and how does it protect people beyond what the 14th Amendment protects, is to focus on advocacy at the state level. Because the debate right now is sort of like, is the ERA the 28th Amendment or not? And a lot of that is being kind of worked out in all the branches of government. But we have 26 state constitutions with state ERAs. So those are laws on the books that provide protections. Most of them, however, I think unfortunately are underutilized and could use a more robust implementation and treatment. And so one of the things that we're working on is working with state level executives and people, governors, attorney general's office, mayors, to think creatively and broadly about how to expand protections based on gender equality using their state constitutions. There's also a lot of room in terms of, litigating at the state level. We submitted an amicus brief to a case that's being litigated in the Pennsylvania Supreme Court right now, based on the state's ERA's protection of the right to abortion, the right to a Medicaid funding for abortion in that state. And so, these cases are going to be critically important as we move forward in a post-Roe world. The other thing to think about too is that there are also states that are in the process of amending their constitutions. Surprisingly, New York State doesn't have an ERA yet. And so in the past couple of years, the state legislature has been in this incredibly important process of adding an ERA, which has been renamed the Equality Amendment because it's so robust and broad and goes beyond sex, to the state constitution. So that's happening right now, as is the state of Nevada. They are trying to amend their constitution to add an ERA. The legislators have passed the ERA, the language, and now it's going to be added to the ballot for voters to vote on. So very exciting. That's signals and represents kind of an advancement in our equality laws at the local level, which is so important and actually very effective. If you borrow a page book from kind of like anti-abortion activists, that sort of strategic long game at the local level too. Part of what happens when you try to amend the Constitution or when you propose new legislation is you have all sorts of hearings and you have a public record of what an ERA is. And that legislative record is rich, and it can be used down the line for judges to interpret the federal constitutional ERA in a really broad way. So that's the other thing that we're working on, as well as to develop a rich legislative history to inform the interpretation of a broader federal ERA.
Thank you. So I think we have time for one more question. So this one is, what do you think is really at the heart of the opposition to the ERA today? And I kind of want to expand that. And Jorie, maybe you could give us a little international perspective on this, and what is it could talk about opposition to gender equality in other places as well.
Well, in terms of the opposition, in other countries, I'm not as, I don't want to venture some examples because I don't want to go too specific because an example doesn't come to mind, but what does come to mind in terms of the opposition in the US in particular, which I think is different. And I want to pull out the opposition to the US as perhaps a different opposition than we see in other countries that, there might be more cultural or religious competing laws and ideas around gender equality and sex. But in the US, the opposition that we're today really focuses on, and Ting Ting probably has more information, correct me if I'm wrong, is really rooted in abortion rights and the treatment of transgender individuals, which I think is something that the opposition is hanging their hats on, almost as kind of a fear-mongering tactic on what equal rights amendment, the effect of the equal rights amendment would be. And I don't know, Ting Ting, is that what you're seeing too on the US side of opposition?
Yes, for sure. I mean, so the opposition to the ERA movement in the 70s and what made it so effective was that, there was a kind of a ringleader, Phyllis Schlafly, who to me was actually quite a feminist. I mean, she had like a boatload of kids. She was a mom, she was super educated. She went to law school. She did all this stuff, and that is the definition of feminism. But she unfortunately channeled all of her energy toward defeating the ERA. But certainly at that time, it was a kind of a classic sort of like conservative Republican playbook, or conservative playbook at the time, of just fear mongering and instilling this idea of like a zero-sum mentality of kind of like, if you give rights to these people, we're going to lose out, right? It's like a piece of a pie. And and there's a limited amount of rights available out there. And her fear, her tactic was also instilling fear in the minds of housewives, to be honest, whose kind of like economic resources and independence was dependent on kind of like a family unit and their husbands, and also is based on this kind of like understanding that the husband represents the kind of like public sphere, working in society, represents the family, and then the wife is at home in the kind of private sphere, right? And so it really worked, and it worked to mobilize housewives who were really fearful of losing their rights as housewives, and you see kind of this fear mongering and this kind of zero sum kind of tactic being recycled over and over again. You see that being applied in the kind of like the transgender athletes context as well. So that kind of like political fear mongering is just a strategy that I don't think has really evolved over time, because it's effective. The other thing to think about too is that at the time when the ERA was kind of like failed to achieve the 38 states state ratifications, due in part from Phyllis Schlafly's very effective like campaigning against the ERA, the things that she sort of talked about was, gender neutral bathrooms and same-sex marriage and women in the military. And, all of these things have come to pass without an ERA, right, in the intervening years. And first of all, this country did not fall apart. And second of all, I think we're a stronger nation and a better society for it. And so the fears now of like, oh, well, the ERA is going to mandate, gender neutral prisons, right? The ERA is going to do all this stuff. Well, no, these are laws. The constitutions have principles that are enshrined as the kind of like foundational document of the country, right? Congress can be empowered to pass laws. States can be empowered to pass laws, and they do. If there's a huge public policy for sex segregating prisons, it would have happened. There's no law that has ever been proposed or passed in that realm. And so that it's kind of disingenuous to say, well, if you pass the ERA, which guarantees fundamental equality to all, regardless of their sex, it's not just about women. The ERA doesn't even say women. And connected to something extremely highly unlikely and has never been even proposed, in actual legislation is extremely disingenuous. The other thing that I have to say too is that you can't prove something with a negative. You know, you can't say this is what the ERA isn't in order to advance equality in this country and to change the Constitution. The ERA is about imagining what we can do to improve this country. You know, we have, and we're coming out of a huge crisis of so much pain, so much death because of COVID, and also the ensuing economic crisis. But what the ERA does is it changes the framing and the conversation around equality. The 14th Amendment really does not go far enough. The 14th Amendment, has restrictions. The 14th Amendment, under the current interpretation, only looks at intentional discrimination, but not discriminatory impact. So if you were to look at a law that doesn't say anything about sex, but clearly has an impact on a certain gender, right? The 14th Amendment wouldn't protect the people who are being discriminated against. You know, I think that's pretty wrong in an age where a lot of laws can be neutral, but can have huge impact on people without actually saying that. The other thing is the 14th Amendment, the ways in which it's been interpreted by the courts, especially in the recent years, has been extremely neutral on its face, which means that the 14th Amendment has been used to undermine equality by defeating laws that are meant to, fix historical inequality, or to, help people who have historically been disadvantaged. You see that in the COVID context too. Biden, his infrastructure plan, in one of the packages, it was meant to expedite the applications of women and minority-owned restaurant owners based on a historical sort of like marginalization of people who had less resources to own restaurants and to, sustainably maintain restaurants and to benefit from owning restaurants, right? So there's a whole history. It wouldn't change the amount of the check. It wouldn't change any of the conditions. It would just expedite the checks. So a certain group of people who've been historically marginalized get the checks a little faster than, let's say, white male restaurant owners. Somebody named Mr. Vitolo sued and won in the Sixth Circuit because the 14th Amendment does not discriminate, right? Based on sex or gender. And so if you want to create a law that actually benefits people and fixes inequality in this country, you can't look to the 14th Amendment, at least the way that it's being interpreted right now. So we need a fix to that, and the ERA can do that. So what I want to say is the ERA is about imagining us being better as a democracy, and not about saying, well, it's not about that to placate sort of people on the far right who are just using it to create political talking points.
Thank you, Ting Ting. So that's all the time we have for today. I want to say thank you to Ting Ting and Jorie for this wonderful conversation. I feel like I've learned so much. And thank you everyone for joining us. I do want to just shout out that API brings you all of our programs for free. If you enjoyed this program, please consider going over to alicepaul.org to make a donation. I also want to plug our next event. We're going to be having the first filming in our feminist film series on June 11th at 8 p.m. We are going to be showing My Name is Polly Murray outside on the lawn at Paulsdale. And you can find more information about that on our website. So thanks again, Jorie and Ting Ting, and thank you all for joining us tonight.
Thank you. Take care, everyone.
Bye, everyone.